Maneka Gandhi vs. Union of India, AIR 1978 SC 597. This case is a landmark judgment which played the most significant role towards the transformation of the judicial review on Article 21 of the Constitution of India, so as to imply many more fundamental rights from Article 21. This case resolves around the concept of personal liberty, which first came up for consideration in the A.K. Gopalan's case. Fact of the case: Regional Passport Officer of Delhi sent Maneka Gandhi a letter asking her to submit her passport within 7 days because Government of India decided to impound or seize her passport on the ground of public interest. Thereafter, Maneka Gandhi wrote a letter and asked for statements of reasons why her passport is to be impounded. Thereafter, she was told by the Ministry of External Affairs that there were orders not to issue her a copy of the statements of reasons in the interest of general public. Thereafter, she filed under Article 32 of the Indian Constitution a writ petition challenging the order on the ground that it violated Article 21 of the Indian Constitution. Article 21, under the heading Protection of Life and Personal Liberty, states no person shall be deprived of his life and personal liberty except according to the procedure established by law. Questions of law. These were the 4 questions of law that were before the court. First question of law was whether right to go abroad is a part of personal liberty granted under Article 21 of the Indian Constitution. Secondly, whether the Passport Act 1967 prescribes a procedure as required by under Article 21 before depriving a person from the right granted by under Article 21. Third question before the court was whether Section 10 Subsection 3C of the Passport Act is violative of Articles 14, Article 19, Clause 1, Subclause A and Article 21 of the Indian Constitution. Article 14 says about rule of law, equality before law and equal protection of law. Article 19, Clause 1, Subclause A is about freedom of speech and expression, and Article 21 is about no one will be deprived of his life and personal liberty except according to the procedure established by law. The fourth question before the court was whether the impugn order of the regional passport officer is in contravention of the principle of natural justice. Judgment of the court. Firstly, the court held that the procedure depriving individuals of their right to life and personal liberty need to be just, fair and reasonable, not fanciful, oppressive and arbitrary. Secondly, the court held that the question whether the procedure prescribed by law which curtails or takes away the personal liberty granted by Article 21 is reasonable or not has to be considered not in abstract or hypothetical consideration. Abstract and hypothetical consideration means not to be considered in imaginary situation, but in the circumstance, the purpose which the act is intended to achieve, and in the circumstance of urgent situation which those are charged with the duty of administering the act may be called upon to deal with it. The court moreover held that the right to travel abroad falls within the expression personal liberty and is thus a fundamental right under Article 21 of the Constitution. Court validating the Section 10 subsection 3C of the Passport Act, which states the passport authority may impound or cause to be impounded or revoke a passport or travel document if the passport authority deems it necessary so to do in the interest of sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interest of the general public. But it should be used sparingly, rarely, in rare cases, and with great care and circumspection or caution. With respect to the power of passport authority to decline to furnish reasons for impounding the passport, the court held that the law cannot permit the exercise of such a power to keep reasons undisclosed if the sole reason for doing so is to keep reasons away from judicial scrutiny. Moreover, the court, although held the Section 10 subsection 3C valid, but court held that wherein impounding order is made under the section with the aim of abridging freedom of speech and expression or the right to carry on a profession, that order would stand invalid. Recognizing the interplay of Articles 14, 19 and 21, the court held that Article 21 does not exclude Article 19, and the law prescribing the procedure for deprivation of personal liberty of a person will have to stand the test of both Articles 19 and 14. In this case, a new doctrine of post-decisional theory was evolved. This doctrine means hearing which takes place after a provisional decision has been reached. Thank you so much for giving me your valuable time. If you have any doubts, do comment and I will answer in the best possible way so that your doubts will be cleared. Subscribe the channel and to hit the bell icon. I'm gonna post regularly law contents.